What is going on, everyone? It is Mark Reel, the Father's Rights Attorney, and you are listening to another episode of the Father's Rights Playbook. And on today's episode, we have attorney Priyanka Bhattacharya of our Riverside, California office. Priyanka, how are we doing?
Good. How are you, Mark?
Doing well. And so on today's episode, we're going to talk all things child support. Major topic for most men going through the family court system, and lucky enough to probably, at least in the Inland Empire, attorney who's probably done more child support hearings than any other attorney. So, Priyanka, to start this off, walk me through, how is child support calculated in the state of California?
Sure. In the state of California, child support is calculated depending on your income, the other party's income, and the percentage of visitation that either parent has.
Yeah. So, in short, it's pretty simple. It's a calculation.
Yes.
You may hear the word disomaster used along that. So the primary factors are, I would say the primary factor is the custody split.
Oh, yes, absolutely.
And then each parent's income. You do throw in some tax-related stuff that goes into that. But in general, it is how much do you make and how much do you have the kids. That's really simply all that matters.
Yes.
So when a guy comes in and child support is part of his matter, whether it's a parentage, a child custody, divorce, even sometimes a domestic violence restraining order, how does that process start? So walk us through from the beginning. Child support is an at-issue piece of a case. What's the first thing we're going to ask of that client?
So the first thing is, how much custody do you have? And sometimes a client comes with an open custody case and a child support case. So the primary thing to deal with is the custody part, because as you mentioned earlier, the custody is the most important part to determine child support. Once the custody piece is resolved, it is generally advisable to then move on to child support, because once you are in front of the judge, you can argue that you have this much custody, you're visiting your kids for these many days a week, but it is a whole separate issue when you can argue, Your Honor, this is the court order custody and visitation schedule, and my client has this much custody.
And you bring up a good point, and a lot of guys lose this in translation. It's the amount of custody you have. If a piece of paper says you have 50-50 custody, it gives the judge something to go off of. If you don't have a custody order, it's your word versus her word. And with child support, it's technically not even supposed to be what the court order is. It's what is actually happening. So I think a common thing we see is that one parent or the other, let's just be honest, typically it's the father, has some weekday time or some time that's a shorter block of time, and they aren't utilizing it. We see attorneys, we see parties argue that, hey, this time's not even being used. Her actual custody time that they have the kids is 27%. That's what we should use, not the 37% in the custody order. So can you talk a little bit about that?
Yes, absolutely. So you're right. Even if any parent has 50% custody on paper but exercising only 30%, then the judge will go with 30%. The rule is how much custody you're actually exercising. Mm-hmm. Now, this is the reason if a client is coming with an ongoing custody battle, that needs to be resolved first, because sometimes, and let's be honest, California is extremely female favoring, and sometimes when the clients have multiple times mentioned that mother is not letting them visit enough, intentionally withholding the child from father, and then when you go to court for child support, mother is arguing that, Your Honor, he never came to visit on these days. He's just visiting alternate weekends, which is less than 30%. And yes, you can argue that no, that is not accurate, Your Honor, but it's a child support court. The judge will just consider 25% and move on.
Yeah, I think that's a big piece that men need to understand is, actually, let's roll it back. So men need to understand that child support is separate from child custody. They can't withhold the child if you aren't paying child support. You can get in trouble in other ways, but they cannot withhold the child. But let's talk about the different ways that child support can become an issue. So you have the Department of Child Support Services, which is the state getting involved, and then you have child support coming up as a matter within a parentage case or within a dissolution or potentially even within a domestic violence restraining order. So can you walk through the differences in process there?
Yes. So when the DCSS, Department of Child Support Services, get involved, generally one of the parent, and it is in our case, most of the time it's the mother who has contacted the state and has opened a child support case. In that case, the father gets served some documents from the Department of Child Support Services. Now, the problem arises that, and which is it's very natural that when you are getting served with some papers from the state, you will freak out, you get nervous, and you wonder that, oh my God, I need to respond immediately, otherwise the state can penalize me, the state can cancel my driver's license, the state can take all kinds of action. Yeah. And to top it all, the state actually calls you and says, hey, we need your income and expense declaration, we need your financial information in order for us to proceed. That is the breaking point for multiple people, which is very much understandable.
Let's talk about that. So you get paperwork, and the biggest challenge is a lot of times you get this paperwork in the mail. You cannot ignore it. Because I promise you, if you ignore this paperwork, they will go make a child support order. And Priyanka, when they make an order, whose information do they use?
Mother's.
The information the other party provides. So that's the biggest challenge. And that's an issue because if she goes out and gets an order because you ignore it, and initially with DCSS, they're going to send you paperwork to gather information. And we get guys that'll say, oh, I don't have to do this. I don't need to do this. I'm sorry, but if the Department of Child Support Services sends you asking for information on your income, on your insurance, that type of stuff, you absolutely need to get them that information. Providing the true and correct information is the only way that you can ensure that you don't get a child support order that is more than it is supposed to be. And it is scary because you have the Department of Child Support Services versus Father A, and mom will be listed as an other party. My favorite case is the ones where mom's really bad, doesn't deserve custody of the kids. We go get custody flipped, and then they're making orders against the other party. Those are always fun ones. But when we go to family law, on the family side, it's a box you can check. So you talked a little bit about needing custody orders. Walk through kind of the process of getting that child support order or what you'll see when it's part of your child custody matter or part of your divorce.
Sure. So when it's part of the divorce or the child custody matter, it's a little bit simpler process because you're going in front of the same judge.
Cheaper too.
Yes, actually. And I say the same judge because generally when the department is involved, the judges are different and you basically need to explain every single detail about your custody to the other judge as well. So in the family case, it is the same judge. The judge is already aware of the custody history that is going on. And if on a particular day we are so lucky that all the documents from the other side have also been filed on time, then we can actually get the custody order from that judge and the child support order. And it's the same disso master and the ex-spouse that this judge uses, but this judge also uses some logic, which unfortunately the judges in the child support department courtrooms rarely use because they blindly most of the time believe what DCSS says.
Yeah, so when you go to when it's with DCSS, there's three parties to it. The Department of Child Support Services has an attorney. Then there is the party they're attempting to get child support from, and there's the other party. So, and I think you brought up a really good point. When it's in your family court matter, it becomes a matter of logic. And whether they're supposed to or not, if you've built really good rapport and you're doing what you're supposed to do, judges in the family court side are much more willing to use logic. Also, there's usually a lot more leeway in terms of negotiating out a solution.
Yes, absolutely. Because the good part is in that case, and I'm this actually reminds me of a very funny incident. What happened was, in one of the cases, DCSS was involved, and like you mentioned, there are three parties always, and DCSS always says that we don't represent mother. We are just a neutral party trying to seek justice for whoever needs the support. But that's not true, because in that case, like, one of the calculations amongst many was showing that mother should pay father, and DCSS straight out said, I'm not going to present this to the judge at all. But when we are in family court, it's absolutely different, because there we are actually arguing. And yes, opposing party also has a right to attorney. And if she hires an attorney, very good, because then you can actually have some clear, logical, number financial argument, rather than all tears and cries and emotional arguments from the other side coming about how much they are suppressed by the father and how much they are in need of support and how much father has never been there for them.
Yeah, and that's another really good point. A lot of guys come out, they hire us, the other side's unrepresented. The other side sees that we serve them with the substitution. They know we're on the case. They go out and hire an attorney. As attorneys, we're relieved when that happens. It is much easier to simplify the issues and have those logical discussions and get positive outcomes that benefit both parties when you have a good attorney on the other side. Now, obviously, we have to be ready to litigate. We will fight for for what our clients need and deserve. A lot of times when the other side's unrepresented, everything, even common sense issues, end up in front of the judge. You end up at trial. It's extremely expensive. When in reality, I mean, typically we'll run 3 or 4 different calculations on a child support hearing, and we can generally know the range of where we're at and put our clients in a positive position. So can you talk about that process and how a lot of times when we go into court, we have those multiple potential outcomes?
Sure. So it depends, and when it comes to child support and the other party has an attorney, the one way, and one of my favorite ways, is to settle. Talk to the other attorney, see if we can actually calculate child support and see that, okay, this is the custody, this is your client's position in the finances, like I can see the pay stubs, and let's settle. But, most of the time it doesn't happen and we go in front of the judge. The good part is when it is in family law, we can actually argue hardship deductions. And hardship deduction is extremely important. And females, mothers do it all the time. They get married, they have another child, and they are saying, I need support, and whatever I'm earning, give me a half of hardship deduction, which is about $500. And with 2 kids, it's like more than $1,000 hardship deduction. So when we are in family law, in front of the judge, we can actually also argue that for our client, if our client is living with older parents, if our client has children who are not even, it doesn't even have to be infants, even if they're big. So hardship is one way that will actually significantly reduce the child support. There are other ways, such as work-related expenses, which most of our clients actually go through all the time. For example, buying uniforms or buying any kind of equipments, which is
union dues, health insurance. There's a bunch of levers you can pull, and I think that's where attorneys are give you the biggest advantage in child support, is understanding someone who knows those levers front and back and can pull them, because it's, to be honest with you, you're not fighting for someone to not pay child support. You're fighting to reduce their liability to it. We don't want someone overpaying more than they should be, or increasingly fathers are having more and more custody, that they're not receiving the child support that they deserve. Because that's an interesting dynamic I think we should go down, is the increasing number of fathers who are receiving child support in 50-50 custody situations, in being the primary custodial parent. Nationally, we've seen about a 5% increase in fathers being the custodial parent. So walk me through, what are some of the biggest challenges you see for fathers when they are that custodial parent, when they should be receiving child support?
The primary challenge that I see is still the income. Because even when you have 50% custody, and you should expect that you will receive some child support, because you just do not have 50% custody. You're also helping your child when the child is with the mother. Because most of the time, most of my clients, whenever they have 50% custody, they are taking care of their children during their custodial time, and also buying stuff and taking care of the children when they are at mother's custodial time.
That's a really good point. At 50-50 custody in California, you could still owe child support. Right, wrong, indifferent. I always tell guys, like, hey, this is the law we have to play by. I don't necessarily agree with it, but statistically, still men out-earn women. And so the likelihood is, statistically, is you're going to out-earn them.
And so that actually reminds me of another funny incident, that there's even if you say earn less than mother and you have 50% custody, you can still end up paying child support rather than owing child support, because it is not just the income. The other factors, like you mentioned, union dues, mandatory retirement, everything plays equal important role in determining child support. So if you earn less than the other party, but the other party has significant mandatory retirement or union dues, you might end up still paying child support rather than getting it.
I've even seen it. This was a case several years ago out of San Bernardino County where the dad had, I think when he hired us, he had 35% custody. We ended up getting it. It was a little bit of a wonky schedule because of work schedules, but it was 53% custody mom, 47% custody dad. But dad earned significantly less. Mom filed for child support. Judge sends us to the hallway. We run the calculation. I walk over and hand the calculation to mom. It was straightforward. 2 W-2 employees, very straightforward. And it actually showed mom, despite having primary custody, technically had the obligation of, it was like $97 a month. Now, ultimately, we opted to decline. The client did not want to take child support, didn't think that was right. That's not what he wanted to do, which I increasingly see with men in these situations where their primary custodial parent maybe even have 70% custody. They don't take child support. I'm the big bad man. I don't need it type of situation where I've seen judges actually decline to award women child support in a similar situation, where it actually calculated to 55-45, but the dad earned $17,000 a month while the mom was unemployed. And there was a several $100 child support order despite having the dad having primary custody.
Actually, you bring up an interesting point that sometimes even when men have not just primary custody, like full custody, and mom has zero custody and zero visitation, and we know how much importance visitation plays in child support, even then men have this tendency of saying that, no, we don't want child support from the mother. We just want an amicable resolution to everything that is going on so that we can move forward from every mess. Nobody wants to go to court other than attorneys and judges. So men do not want to be in court all the time. They just want to move forward, and they would never go forward and ask for child support.
Yeah, I think you increasingly see that. I mean, that also is in terms of when you're negotiating these things out. A lot of times I've seen attorneys do this where they can negotiate down a lesser number, and the argument to their client, it's a huge benefit to our client because they're paying less in child support. But the argument to their client is, hey, if you give them a lesser number here, lesser than this calculation, and they may get down to this number, but if you give them this number, the disposition is going to be, they're going to be less likely to come back and fight you on this point.
That is true. And child support is something that court's jurisdiction remains until the child marries or turns 18. It is not like spousal support that if you stipulate to terminate the jurisdiction, it just terminates. So court retains jurisdiction. Yes, when you go to court after a judgment, you have to show a change in circumstances under the Montenegro rule, but you can still go and ask. Even a simple slight change will add to that change in circumstances.
Yeah, and so I think some judges, the burden of change of circumstance is pretty low for them. And a lot of times we'll advise clients, it's, hey, your child support's going to stay about the same. I mean, maybe we got $50 one way, $25 the other way is the range we're looking at. And it's like, hey, it's going to cost $5,000 on a 16-year-old to maybe get a reduction, but maybe actually see more. So I see a lot of times with older kids, you kind of have to have is this worth it conversation with them.
But the most important conversation is about child support arrears, the back pay. Because
they ain't going anywhere.
Yes, it is not going anywhere. If it is ordered, even if you go to court and your child support actually decreases, it is literally in the law that it is on the discretion of the judge whether the judge wants to change the arrears or not. And in majority of the cases, at least in my experience of doing hundreds of these cases, I think once or twice the judge has said, okay, this is huge injustice. I'm going to change the arrears based on the difference in income in all those months. But arrears remain.
We probably get 10 calls a week of guys with adult kids who have hundreds of thousands of dollars in arrears. They can't get a passport. They can't do this. They can't do that. What can you do for me? There were some COVID-era policies that gave us some openings in certain counties. But if you have $250,000 in child support arrears, the likelihood of being able to negotiate those down really at all is near zero.
Absolutely. I mean, I hate to break my clients' hearts, but I have always told them that you cannot change your back pay. What is there, it's there. And another important thing to remember is when you're going to court, say you're actually going to court for the first time, there are no back pay support orders. It is not always advisable to come up with some excuse and get the hearing continued, because you need to remember that you are not paying child support right now because your hearing got continued from November to February. But when you go to court in February, you're going to owe back pay child support from November. Yeah. That is to say, from the date of filing of the petition. Yeah. So that is not going anywhere.
Because sometimes you can see, and there's an entire year that goes by before there's a child support order. In some circumstances, a child support order is not made until trial. We see this where, say, one party's paying for the mortgage and they say that's good enough. But understand that, I mean, and we always give our clients a range of where, hey, realistically, this is what you can expect to receive. This is what you can expect to pay in child support. When those hearings get continued, I always look at a client and say, hey, remember that range we talked about, the likely range? You should probably be saving money towards the top end of that, because if they get an order for arrears, you're going to need to go pay that. And we may be able to get that spread out. Hey, a lot of times we can get it, you pay $100, $200 a month towards arrears, but sometimes that's not even enough to cover the interest on the arrears that have been ordered.
Yes, absolutely. I mean, it is imperative to know that even if child support gets ordered in trial, it goes back to the date when it was filed. So even if it was a year back, you didn't pay anything for a year, but then you'll end up owing so much money.
Yeah.
And I'm not going to take the name of this judge, but I was in front of him, and he used to be a criminal judge. So he's very thorough on everything. And I was arguing about my client's financial position, and he made a really good point. And he actually emphasized on the fact that, does your client really want to get the shock of his life of owing thousands of dollars in back pay, or does he want to pay some amount, continue to pay until we come back, and not get a heart attack of knowing that, oh my God, he owes so much money?
Yeah. I think coming out of COVID era too, this was amplified because so many hearings, so much work was continued out that we started to see guys that were 2, 3, 4 years down the road. COVID hits, couple continuance happen, you hire an attorney, a continuance happens, it moves down the road, and the case comes across, they hire us, and it's 3.5 years since the request, and you're like, hey, you're going to get hit with $500 a month in child support. That's most likely, or you're going to be between $300 and $600 or whatever it may be. But you're looking at 36 months back. You're looking at 48 months back. So all of a sudden, that $500 a month that was manageable is $25,000.
Yes, absolutely. And it is very, very important. That is why when you get served with paperwork related to child support, whether it's family law or DCSS, act immediately. Like, you cannot run away from it. You are probably going to owe a hell lot more money than you would have if you would have acted immediately. It will never go away.
Yeah, definitely. Well, Priyanka, that was a ton of really good information about child support and family court. To our listeners, to our viewers, thank you again. And we'll be back next week with another episode of the Father's Rights Playbook.